Good evening and welcome everyone. In recognition of the fact that we're joined by hundreds of colleagues from across the globe, California, England, Germany, Newcastle and India, I would like to acknowledge the First Nations people in each of the lands in which we meet and their continuing connection to the land, sea and community. For me, here in Sydney, Australia, I acknowledge the Bedical people of the Eora Nation. We pay our respects to their elders, past, present, and emerging. Technology is changing every aspect of our lives. This evening, the Australian Society for Computers and the Law will explore the impact of technology on our courts and the ideal of justice. Thank you for joining us for this evening. We will first hear a keynote address from Professor Richard Susskind, followed by a panel discussion with the Honourable Justice Kirby and Professor Tania Sourdin. We will have an open Q&A session after the panel discussion, which will be moderated by Micheil Paton, the Principal Legal Officer at the Australian Law Reform Commission.
Thank you very much, Marina. It's a great pleasure to be with you after the false start the last time when I tried to join the launch of your society. So can I, informally now, on behalf of the Society for Computers and Law over here, congratulate you on your new venture and hope there was many opportunities for us to collaborate in the future. I've been asked to speak for about 20 minutes, and it's a great pleasure and privilege on online courts. I wanted to organize my thought really in terms of a number of questions. The first is, why should we modernize our courts at all? What's the problem here we're trying to solve? Secondly, what mindset should we have when we're thinking about the future of our courts? After that, I want to ask what the technological options are. How might we use technology to modernize our courts? What objections, fourthly, might there be to this? What does the future hold? Fifthly, and finally, what should we all do now? So as to the question, why should we modernize? The answer to that is very different now from even just a few months ago, of course. The current and most acute difficulty we have is that many courts around the world are closed. Many physical courts are closed. Secondly, there's a huge backlog building up around the world as a result of the COVID crisis. So our physical hearing system isn't coping, and who could have anticipated the dreadful events that have unfolded? But there's a third reason that our system is not coping, and that we've called for many years the access to justice problem, and we've really got no excuse for not having addressed that sooner. There's many ways of expressing that. According to OECD, and I find this remarkable, but only 46% of human beings on our planet live under the protection of the law. In some jurisdictions, there are staggering backlogs, 80 million cases in Brazil, 30 million in India. But the reality is, even in the most advanced jurisdictions like yours and mine, most civil disputes, for example, if we're really honest, cost too much, take too long. The process is unintelligible unless you're a lawyer. And all of this often seems rather out of step in a digital society. So it seems to me there are quite strong reasons for us want to change. The crisis, the COVID crisis, has accelerated the problem, but we shouldn't be in any doubt that for many years our court system was due some kind of upgrade. So what kind of mindset should we have in thinking about the future? The fundamental question I ask is court a service or a place? Do we really need physically to congregate together to resolve all our differences, or might there be different ways that we can actually come to terms with our disputes, our legal disputes? The mindset is not just one of automation. That's to say, how can we streamline, optimize, turbocharge even our current court system? How can we graft technology onto the way we work? That's been the story of court technology for 50 years. For me, the mindset is that of what I call transformation. That's really asking the question, how can we use technology to allow us to do things that previously weren't possible? So it's less about streamlining and improving our current system and more about using technology perhaps to deliver court services in new and different ways. My favorite little story in this context, those of you who have heard me before may indeed have heard this, is about Black & Decker, one of the world's leading manufacturers of power tools. Apparently, when they recruit new executives, they take them off on a course, sit them down in a room, and put before the assembled executives a slide of a gleaming power drill. and say to them, this is what we sell, isn't it? And they all agree, of course, that's what we sell. That's what we do. Trainers with some satisfaction say, that's not actually what we sell, because that's not really what our customers want. This is what our customers want, they say with a flourish, and present a slide with a picture of a hole neatly drilled in a piece of wood. Then they say, that's what our customers actually want. And it's your job to find ever more creative, imaginative, competitive ways of giving our customers what they want. Isn't there a great lesson here for lawyers, courts, and judges? We should be thinking not just about the power drill, our current ways of working, how to make it cheaper, quicker, and better. We should be thinking of, or debating, what the fundamental hole in the wall is, what problem we're trying to overcome. So what are the technical options that are available to us if we're trying to modernize our justice system using technology? Well, this has come very clearly into focus during the COVID period. As physical courts have shut, what we're calling remote courts have sprung up. And if you're interested, I and others set up a site called remotecourts.org. And there we've got, I think, 56 countries have reported on what they're doing to respond to the COVID crisis as their physical courtrooms have closed. The early evidence is positive in terms of the feedback from these systems, but what's very clear is that 3 different categories of system have emerged: the audio hearing, the video hearing, and the paper hearing. The audio hearing is essentially some kind of telephone conference call instead of a traditional court hearing. The video hearing is not unlike what we have just now, this way that I and all of us are engaging in this meeting, using video conferencing to conduct court hearings. And finally, there's the paper hearing, where in fact there's not really a hearing at all. The idea is that evidence and arguments are submitted electronically to a judge who responds in kind. No oral evidence, no physical hearing. I should say the audio and video hearing come in 2 shapes and sizes. There's the partial hearing, where perhaps there is a physical hearing, but some people are participating by video or by audio, and there's the full hearing where everyone is participating by video or audio. So they're the 3 broad options, and the experience we have, and we can see from the Remote Courts project, is that video hearings are actually working rather better than many people had expected. Audio hearings, very hard to conduct, hard to maintain the solemnity of the occasion, and paper hearings are at their early stages. But paper hearings, strangely enough, given they've not really been used that much over the last few months, are nonetheless the main focal point of my latest book, 2019 in November, Online Courts and the Future of Justice. And basically what I'm saying there is that we can imagine online courts in 2 ways. The first I call online judging, and the second I call the extended court. Online judging is, as I've suggested, the idea of human judges, rather than assembling in a physical courtroom and hearing oral evidence, receive the evidence and arguments in electronic form and respond in electronic form. It's, if you will, like a very complex exchange of emails. The key point here, to use a technical term, is the process is asynchronous. Communication is synchronous between human beings when we need to be present at the same time to engage in the communication. A phone call, a meeting, a video conference. Communication is asynchronous, like email or texting, where you don't need to be present at the same time. You send a message, the other person doesn't need to be there at that time to receive and respond. And so it's a different kind of engagement. And it struck me that for many of the cases that come before our courts, particularly the low value, high volume cases, I wasn't convinced that people needed to take a day off work, instruct lawyers, and go through a fairly cumbersome process. And I say cumbersome process, our former Master of the Rolls, Lord Dyson, said of our civil justice system, he said, any system that's got a 2,000-page user manual has a problem. We cannot have ordinary citizens having to leaf through 2,000 pages. So the idea of online judging is a simplified process that allows people to engage with the court, but not in the traditional way. The second aspect of this, the extended court, answers many of the questions that many of you will have in thinking about this. Well, how can a non-lawyer, for example, use such a system? And here's where I get into perhaps trickier ground. My overall premise is this, that in a world where so few people have access to the courts, in a world where, frankly, very few people can actually afford access to lawyers, it seems to me that a court service, and notice I'm not saying a judiciary, I'm saying a court service provided by the state should do more than its primary function of delivering authoritative binding judgments. I think a court service, again, not the judiciary, should provide a wider range of services, specifically that it seems to me in the digital age that people should be able to go online and have some formal help in the form perhaps of diagnostics or flowcharts to help people understand their rights or entitlements. There should be formal help available to point people to the various options that are available to them if on the face of it they have a justiciable dispute. We should, if people are going to be using and engaging with online judging, we should have tools to help people formulate their arguments. We should have tools to help people present and organize their evidence. More than that, we should provide tools to allow parties to negotiate and perhaps settle their disputes without third-party intervention. And even more than that, it seems to me we should have facilities to allow parties to resolve their difficulties with the help of online, a third-party mediator, but not yet a judge. So a whole bundle of services at the front end of the judicial process, often to dissolve or divert disputes. And these I call the extended court. Now, all of this is quite challenging stuff. I accept this because I'm moving towards a vision where we move away from the presumption of someone's got a legal dispute, what they do is assemble in a courtroom, to a presumption or really a requirement that you need to make the case to the judge that any kind of hearing needs to be conducted in a physical courtroom. Why is all of this important? Well, for me, it's all about moving away from the concept of courts developed, designed by lawyers for lawyers, to courts that are genuinely available and accessible to non-lawyers, a phrase I don't particularly enjoy. But with the vision I have, I can see at least a glimmer of a possibility here, A, of providing a route to resolution, where today many people have none at all, and secondly, for self-represented parties, to provide them with a more convenient, less costly, speedier, more intelligible court service. And I even think that this might be more attractive to people who today instruct lawyers. Now, you may think this is all pie in the sky stuff, it's all science fictional, but I can take you to the Civil Resolution Tribunal in Canada, I can take you to China, to the United States, indeed to England and Wales, where we've got a £1 billion reform program, which is devoted precisely to trying to use technology to deliver our court services more effectively. A great science fiction writer once said, the future has arrived, it's just not evenly distributed yet. That's absolutely the case when it comes to online courts. I can point you to bits and pieces of the solution I'm proposing, but perhaps it's not yet been brought together. Judges without courtrooms, justice without lawyers, it all seems rather challenging stuff. So as you can understand or anticipate, many people have objected to the idea of online courts. Now, in my book, I actually spend a quarter of the book raising and answering the objections. It won't surprise you to hear that I think I do meet the various concerns. I haven't got time today to discuss them in detail. I just want to point them out so that you know I know they're there, and perhaps you can read further to determine my response to them. So the first objection is that really this is an economy class service delivered online. The first class service is to people who can afford lawyers and courts in the traditional courtroom, and the rest of us are left with an economy class service. The second objection is that these systems are less open. They're less transparent than a traditional court system. The third is you don't get a fair hearing. A hearing has to be fair, has to be a public hearing, not an electronic hearing. The fourth is that some people are excluded from digital technology and therefore could be excluded from the court system. A fifth is this is going to encourage litigiousness. A sixth is that most public sector technology projects fail. Here's just another example of an ambitious project that will never come to fruition. Now, as I say, I have and devoted a huge amount of my life to thinking about how these objections might be met, not for their own sake, because what I really care about is that we can offer greater access to justice, that we can offer a resolution to people's legal problems in a way that's genuinely affordable. I would say as a generality, though, that most critics of these ideas, mainly lawyers, fail to look at the system through the eyes of users. They tend to criticize the idea from the point of view of lawyers and the systems and processes with which they're comfortable. The bigger point, though, is often in the name of justice, where they say that justice won't be delivered, critics are actually missing the opportunity to reduce injustice. What does the future hold? Well, what I'm about to say, I say with a little bit of hesitation, because I know it often becomes the focal point of discussion. And indeed, I know this is something Tania is working heavily on, and indeed something that Micheil wrote on as long ago as 1998. But the question that's often put to me when I talk about online judging is, why does it need to be a human judge at all? What about a computer judge? And I wrote my PhD in Oxford in AI and law in the 80s, so I've really spent most of my life thinking about this. So I think there's actually three different questions here when people talk about a computer judge. One, can a machine work like a judge? Can it use judicial-like reasoning processes? And the answer to that neurophysiologically and neuropsychologically is currently, I think we're a million miles from developing a machine that can work like a judge. Secondly, though, can perhaps an AI system deliver legal decisions with reasons? Because that's what judges do, decisions with reasons. And again, much as I respect my colleagues in the AI law community, other than quite confined areas using quite basic technologies, we're nowhere near having systems to the level we would want to deliver decisions with reasons. But there's a third possibility here, and that takes us to the idea of what I call outcome thinking. I often say patients don't want doctors, patients want health. I say that people don't want architects, they want safe, beautiful, functional buildings. And similarly, I think we have to accept that people don't want judges and lawyers and courts, they want their problems resolved. So there's a big empirical question about what it is that people actually want. But insofar as people want their dispute resolved in a binding and authoritative way, might there be an entirely different and new way we can do this? And one of the thoughts I have, and it's a thought experiment at this stage, but it gives you some insight into what might be very different, is the idea of using prediction machines to provide determinations, authoritative determinations from the state. And I know this is a big leap, but bear with me. There's quite a lot of work being done around the world in developing systems that can more accurately than human beings predict the outcome of cases. Sometimes they work on the basis of past legal sources, law reports and so forth. And other times they actually operate on the basis of quite objective factors. Turns out if you know enough about, across a large data set, who in a particular case, who the judge was, who the lawyer was, the nature of the claim, the size of the claim, and so forth. Turns out using computational statistics, you can often predict the outcome of the dispute more accurately than using the legal method. Huge debate we can have about that. But just imagine if we do perfect that technology, and we're really not far away. What about the idea of predictions as determinations? So let me take you to Brazil with, as mentioned, their 80 million cases in their backlog. Now, with all the will in the world, all skeptical lawyers listening in, there is not a chance on earth that these 80 million cases will ever be sorted out by judges and lawyers and courts. And so for most people, these disputes will go unresolved. So here's the thought experiment, the alternative. Imagine if it was said to the parties involved in a particular dispute, our court system, our court service has developed a system that in your kind of case can actually predict the outcome more accurately than any lawyer, and it's based on all past cases of this court. Would you accept, this is a proposition to the two parties, would you accept the prediction, the outcome or the output of that system as a binding determination of this court if, for example, its degree of certainty is perhaps 95% or more? Now, I'm not recommending that today. I'm simply, I hope, opening your minds to the possibility that we might think in an entirely new way of how it is we deliver, or the state delivers, authoritative binding determinations. And of course, I know about the two key problems. There are many more. The opacity of data, the bias of data. The opacity of data point is that these predictive systems work on the basis of machine learning, and they don't really provide reasons for the decisions they offer or predictions they offer. Secondly, of course, I know about the issue of bias inherent in the past data. It's not to say that I've cracked these issues. I'm simply raising a thought, a process, perhaps an option for the future. So what do we do now, folks? Well, what we've got in COVID, and it has been such a tragedy, and I hope everyone listening is in good health, but there's another way of looking at it that in so many areas of life, it's been like a massive unscheduled pilot, a huge experiment, a proof of concept. What we've had to do is shut physical courts and use various online techniques instead. What's vital, though, is that we assess what's gone well, what hasn't gone well. We gather data on the technical, business, cultural, and justice aspects of what we've seen in action. We can identify perhaps what we should keep in the post-COVID era and identify where it is we must go back to our old ways of working. We used to say when we were people in my field, when we're thinking of the future of courts, that there's no evidence from the future. But now there's a possibility of policy making in the future of courts to be genuinely evidence-based. Above all else, what I think we've seen here is an opening of minds. Our court system in England and Wales derives from a system that was introduced about 150 years ago, more indirectly 900 years ago. There might be a different way of working. So our challenge, I think we've got three challenges today. The short-term challenge around the world is to stabilize and improve the ad hoc systems that are currently being used, and so doing to minimize any disruption for the remainder of the crisis. The medium-term challenge is to industrialize, I believe, what's gone well during the crisis and ensure this experience of remote courts is seized upon, not least in handling the backlog. But looking longer term, I still think there's a bigger challenge, radically to reconceptualize, to redesign our court system, not for its own sake, but because just now, most people don't genuinely have access. We need to put in place a new configuration of people, of processes and technology and physical spaces, but a combination that's superior to what we have today, that's sustainable and that's more accessible. For those of you who are listening in, my plea is to get involved. We need everyone's help during the crisis to make sure that these online alternatives, these remote alternatives to court systems, keep access to justice a reality, keep the rule of law indeed up and running. But we also need your help in rethinking the future of our court system. We're actually, I believe, at the dawn of a great new era now, a time in which it will genuinely be possible for everyone to understand and enforce their entitlements. That's not possible under the current system. And so I think we should look ahead to seeing how this is perhaps our legacy for tomorrow's, I was going to say clients, but it's for tomorrow's citizens. And not just in Australia and the UK, but right around the world. Thank you very much, ladies and gentlemen, for listening in.
Thank you very much, Richard, for that amazing speech. And I'm sure that there'll be many questions that will be asked by the audience. I'm Tania Sourdin, and if I could encourage the audience to use the Q&A button at the bottom of the screen to ask some questions which we'll return to after a discussion between Micheil, Kirby, Richard Susskind and myself. First of all, though, I would like to acknowledge the Awabakal people, who are the traditional owners of the land upon which I'm joining you tonight. And I would also like to pay my respects to any First Nations people who are joining the webinar this evening. I've got a couple of questions as well as observations, and my first one is in relation to Richard's material on online courts. And Richard, in your material on online courts, you've proposed a 3-tier model of courts, with the first 2 tiers being much more focused on ODR, online dispute resolution and case management, and the last tier being much, or essentially reserved, if you like, for judicial adjudication. And you envisage that these first 2 tiers would be controlled and monitored by the executive rather than the judiciary. Is this model proposed by you for some particular reason? For example, do you have concerns about the capacity of judges to be technologically innovative, or are you concerned that they might, for example, be disinterested?
Oh, no, it's nothing like that. That's not the motivation at all. I come from an entirely different direction. I just believe that if we're going to offer far wider access to justice, and we're also, as I'm told on a daily basis by judges, we're going to divert cases away from judges, because many of them don't really deserve judicial time and are a waste of the party's time as well. If we're trying to either dissolve disputes or divert disputes, we have to have, as it were, and I've rephrased it, and I call it a front end to the system. And by the system now, I'm meaning the judiciary. And I'm saying this needs to be provided by the state. I really don't think it's for judges to be offering advice or judicial officers to be offering advice on people's rights or entitlements. But I think it is not unreasonable to expect the state. We're all expected to clarify what our legal position is. We're all expected to know what the law is. That seems to me, and has done for decades, seemed to me to be an entirely improbable proposition. So is it too much to ask that the state can't provide us guidance on what our legal entitlements are, that it can't help us if we have a dispute to equip ourselves appropriately. It just seems to me that that is absolutely not for judges to do, certainly in a common law system, where in an adversarial system where judges are essentially listening to competing arguments. As you know from the debates about case management, there's concern about judges being too interventionist. So I'm saying there's a whole bundle of processes that can help court users be far better equipped if they do appear before judges, but can also help them dissolve the disputes rather than resolve them, or divert them to other parts of the system, perhaps to alternatives. Now, there's a philosophical, it's probably a principal issue here that drives my book, and that is to take back to 2014 when I was asked by our Civil Justice Council to look into the possibility of using online dispute resolution in the courts. The philosophy of most people then was, are there ways we can take, in this case, low value, high volume civil cases out of the court system and put it in the private sector? So we looked at ODR, which is largely ODR, private sector, and we thought, hang on a second, if there are really good ways of helping manage and resolve disputes, surely in a digital society, rather than outsourcing that to the private sector, we should bring that within the state, so we can increase public confidence in the rule of law and in the bindingness of decisions when they eventually, and if they travel to judges in the end. So it was a rule of law argument I had for suggesting that this development should be part of, in the broadest sense, the court service, but not part in the narrower sense of the judiciary. I know there's a long answer, but I've just written an article that's published in the online publication from Harvard called The Practice, where I, for practical reasons, because of the COVID crisis, have said maybe these front ends, these extended courts, at least for a while, should be provided by the private sector, because I fully appreciate with the backlog and so forth, there's no way court services are going to be introducing what I'm calling extended courts. As a matter of principle, I prefer that the state provided these services, but as a pragmatic matter, I can see that these front ends might be provided by the private sector too. Long answer, Tania, sorry, but it's a complex and a big issue.
No, it is a complex and a big issue, and I think some other countries around the world have referred to this as e-justice provision and haven't located these types of services within the court system at all, but located them outside, even if they have been state supported. My next question is really to Micheil on this, and really it turns on this issue about the constitutional and other concerns that could be raised by this type of online court model, that is the type that Richard's proposed, in a country like Australia.
Well, there's so much in what Richard Susskind said that I agree with, that it sounds a bit of a dampener for me to introduce the Australian Constitution into all this, because he's over there in those windy, rain-swept isles without a written constitution. And he gets by without the rigidities that come with a written constitution. The Australian constitutional situation is a sort of compromise between the American written system and the common law system, which has the great flexibility. He says we should be bringing disputes into what he said was the state. And we should be doing that because at the moment, the ordinary person can't, even a middle class person really, can't afford the lawyers and the costs of the courts and the proceedings, and therefore they're really having to give up or to settle on a less satisfactory way of resolving their disputes. And I think he quotes in some of his writing the OECD figures, which say that a certain percentage of people, I think it's was given at something like 47%, can't afford in a state to get to the courts. I would think it's much higher than 47%. I would think that the majority of people can't get to the courts. So that's our problem, and the need is to solve the problem, and there's no doubt technology is going to come to our aid. But in Australia, we've got a particular problem, which is in a way a blessing and in a way a problem. The blessing is that because we have this written constitution, because it has provisions in it as to our governance, because they have a rigidity to defend our democracy and our independent courts from the ever-willing intrusion of executive government or the legislature into the role of the courts, you've got to have an umpire. And in our system, that umpire, the constitutional umpire, are the courts. And therefore, matters which involve the interpretation of the Constitution, for example, our recent case in Australia, can an Aboriginal Australian ever be refused entry into this country as an alien, or is that person, by reason of their Aboriginality and by reason of our history and the injustices that have been done to the Aboriginal people, which foreigners will hear us saying how we respect the Aboriginal people? Well, we didn't always respect the Aboriginal people, and the courts have come to their defence and protection. So the bottom line of what I'm saying is there's a lot in what Richard has said. There's an enormous amount that can be done. We can bring matters into the state. I'm not so worried about that. But if you're bringing it into the state in the guise of or utilising or involving the courts, they have to be courts of the kind that our Constitution envisages are going to have the independence in order to do the job of the constitutional umpire, and in particular in matters that the Constitution requires protection of criminal accused for a jury trial. Now, what does that mean? That can only be determined by the courts. No administrator can just say, well, this is our dream, this is the better way, we can have jury trials done in some informal way. It has a constitutional content. And so that is a rigidity. And at least when you're dealing with a country like Australia, you've got to be ready to deal with the rigidities. And if you don't, then what you set up or try to set up will be held to be unconstitutional, and then it gets nowhere.
I think what Michael's really pointing to, though, is a capacity for these services to be provided within a court. However, they would require judicial supervision and monitoring for that to be the case. And they couldn't be provided by some separate entity that was called the court, that was effectively set up and maintained by the executive, which is, I think, where Michael has also taken us to. I might now move to
Can I respond? First of all, Michael, thank you very much. It's we go way back, and it's always a privilege to be in debate with you. Although we don't have a written constitution, we do have similar concerns, and of course, you can imagine that many judges in the UK share your worry about the extent to which, in any way, this extended use of court service might impinge on their impartiality and independence. So I'm sensitive to the constitutional point. I respond in a number of ways. It seems to be possible, despite that, in the UK to provide the kinds of extended services I'm talking about by what we call Her Majesty's Courts and Tribunal Service. That's the state body that supports the judiciary, but is now extending itself so it can offer other services. I'm also entirely open to the idea that you could have another state entity that helps prepare people for their interactions with the court system. And I'm equally prepared for the idea that if it's unconstitutional, we can have this as a front end that sits beyond the state, but perhaps is delivered in the spirit of a public service, very much supported by pro bono lawyers and by educational bodies and so forth. And so I'm not riding roughshod over the Constitution. We should want everything that we do to be consistent with the Constitution. But in the end, it seems to me, and I'll continue to say this, that it's a bizarre kind of constitution and a bizarre kind of legal system. I'm not talking about Australia, I'm talking as a generality that doesn't offer reasonable access to an affordable system. And it seems to me, we need to adapt. So if you look at the European Convention, Article 6 that everyone talks about, saying that it's not a fair hearing when it's done electronically because it's not public, I think we recognize that we may need to revisit our conception of what public means. And similarly, it may well be that we need to revisit some of our fundamental constitutional principles because our world has moved on. What really matters to me is that people can understand and enforce their entitlements, and that we have a constitutional settlement that supports that. And so, as often is the case, we're seeing in AI more generally, we're seeing the technology raises some pretty fundamental challenges to many of the assumptions we readily take for granted.
Yes, but I agree with a lot of that. I'm on your side here. I'm on your side, but I'm just warning you. You can't just go wandering around the world and entering into different countries which have a long history of their legal organization. We copied New Zealand at the turn of the last century into the labour arbitration system. And it lasted until 1956. And then it was struck down because it was said by the High Court is basically inconsistent with the system which we have to have in Australia to decide court-like decisions, that you have a body that is looked like a court, it has judges like a court and acts in many ways like a court, but which has not got the limited and special role of applying a pre-existing norm to the facts as found. And that requires the rigidity that the High Court of Australia said was necessary in order to make sure that you have a neutral umpire. And that's the law of this land.
And I would hate to think it was ever thought that I was, as you put it, wandering around the world, not respecting constitutional rigidities. What I'm wandering around the world doing is saying, I spent my whole life thinking about different ways we might help offer access to justice. Australia, here's some ideas for you. I wonder if you can accommodate it. You might not be able to accommodate it. I would never want to be thought to be riding roughshod, but there's something that's so important here that I am prepared to write books, to make speeches, to try and open minds and to try and encourage people to think differently. It's never with a disrespect to the way that people run their countries, but it is with a challenge. And so I'm wanting to collaborate rather than in any sense confront. But if there's some young lawyers listening in who are tomorrow's future judges, if there's some activists and policymakers who believe, as I believe, that we have a court system, or we have court systems around the world that might be improved, then if some of what I say is of help, then that's a great thing. But there's never, ever, and never has been an intention either to disrespect or ride roughshod, as I say, over constitutional principles. But I do feel strongly that there's a lot at stake here. And I do think, as lawyers and judges, we should be concerned that the system of which we're so proud is not actually providing the reach that we would want. So my self-appointed role in life is to open people's minds, certainly not to advocate in particular jurisdictions how they might work differently.
By the way, I'm all in favour of you wandering around the world, and I'd like to be doing a bit more of it myself. And as soon as COVID is over, I hope to join in this and many other things. I think cross-pollination and of ideas and so on, that's the way we develop, and especially the common law that needs to be shaken in its rigidities.
I suspect that the two of you are actually not that far apart, and this is really a design question about how some of those ideas that Richard has put together can be applied in the context of different systems, and about what that means in terms of the redesign and the thinking that goes into them. I'm going to now just ask some questions about Judge AI. And a little bit of commentary first. And there is the prospect, and Richard referred to it, of a form of Judge AI eventually replacing human judges. And I think he, like most people, considers that we're some way off from a full Judge AI formula. And indeed, initially, I think you, like myself, consider that there'll be forms of Judge AI that support judges. They could assist with template decisions, and indeed they could potentially nudge or correct judges, as is the case in China. There is this notion, though, that in some time into the future, Judge AI will replace some human judges, and that's more likely to be at the lower levels. And I think even Richard's referred to the lower cost claims when you've got high volumes of those claims. And I suppose there's a couple of questions that flow from this. Firstly, to Richard. Should there be some human judicial decision-making that is never replaced by a form of AI? And if you are looking at judges, and I think many of us are, judges taking on a sort of supervisory and monitoring role in relation to supportive forms of judge AI, how realistic is it that judges will actually be able to do so, particularly if they're members of a very busy court and have high caseloads? There's quite a few bits in there, so thank you.
Yeah, so the first is a moral question, the second is a more practical question in some ways. And I think the first is a moral question, to which, in a way, my answer is no better than anyone else's. But when we think of AI more generally, there are certain activities that I think most of us would feel uncomfortable with machines engaging in. So let's take us down other fields because we're less personally involved. You take something like medicine. I think most people would say that even if it was operating a very high standard, they'd be uncomfortable about an AI making a decision about when to turn off a life support system and then flicking the switch without any kind of human intervention. Most of us would say that just doesn't feel right. So we draw these moral boundaries. And I would say a couple of things. A, that they vary from place to place. Different people in different countries have different views on these moral issues. And secondly, they certainly vary over time. And what we may think as abhorrent or very deeply disturbing today, in 50 years' time, we may think differently. And that takes us into a whole set of issues in the area of metaethics about objectivity and subjectivity and morals and so forth. And so my own view is, yes, I can see there's certain kinds of decisions that I would always want to be taken by a human being in the courtroom, or the virtual courtroom. It seems to me that the idea of the moral buck stopping at a machine is not acceptable in all cases. But I do genuinely say that my own view on that issue is no more valuable than anyone else's. It seems to me that, as with, and I go back to the 80s and in vitro fertilization, when that kind of technology was being developed, it raised deep and disturbing issues about the proper limits of science. And we have public debates and policy emerges, and it tries to reflect common morality, which varies over time. And so, but in the broadest of terms, it's hard to differentiate sometimes that issue from what machines are capable of, because very often the most contentious cases are the hard cases where it's least imaginable that the systems would actually be able to take on the decision-making process anyway. But I think it's helpful just to disentangle. Are we talking about what's possible? If a machine could do anything, are there some moral boundaries we would draw? And I today would say yes, but I might not think that in the future. And certainly, as I've written, but when I wrote my first published article in the mid-80s, I talked about the computer judge. I actually really didn't like the idea at all. It stirred it within me a deep distrust. And as I've written more recently, I don't feel the same way about that. And that's perhaps because other moral considerations have trumped that view. It seems to me that on some occasions, it will be more important that we offer access to justice than a human being is always involved. So that's the moral issue. You did ask the second question about supervision. And it occurs to me that, and you asked the question, will judges have time to supervise? How could you mix your day job of judging with your spare time job, as it were, of monitoring the outputs of your fellow systems or systems that are your fellow judges? Now, there's part of me that thinks that as systems become more advanced, as our systems become increasingly capable, the relative contribution that human beings can make in many of these occasions will diminish over time by definition. And I think there will be a certain time when we're actually just fooling ourselves if we think that judges are adding anything and lawyers are adding anything, say in 50 years' time, when AI systems way outperform us in so many areas of life, that we think that we're adding anything substantive by our little bits of human being in the loop and supervision. So I think it's a temporary phenomenon, is my observation, that in the early days of these systems, when they're not performing at a very high level, we will presumably want to audit their performance. We might do that on a sampling basis. But my inclination is that that is almost a job in its own right, rather than something that a judge squeezes into their spare time.
Interesting. I've got a follow-up question to Micheil, which is really about what he sees as the benefits and the risks of a form of judge AI.
Well, I mean, the benefits are that otherwise you're not going to have the processing of very large numbers of cases, and people either have to give up or they have a less than satisfactory resolution to real, genuine legal disputes. I mean, when I was a young solicitor, I would tell people if it wasn't a stake that was worth, say, £500 in those days, forget it. It's just not enough money, and the money for the lawyers will outweigh it. And of course, that figure has changed, but the problem hasn't changed. It's simply expanded. I think it's very interesting from Australia's point of view to have watched what was going on in Hong Kong when all those people were on the streets, and they were not just students, they were citizens of Hong Kong, very concerned about what they saw as the loss of the quality, independent, individualized judge product that had been left for them there. And I think it's really interesting that China, with its huge population and millions of decisions, had to develop a system that would get things done. But ultimately, it has to have some sort of a check so that you're not replicating repeatedly an error. And in Australia, we've got so many examples of that. The Mabo decision is such a great decision because it was made by judges who said, well, for 150 years, our courts have been saying Aboriginal people in this country are not entitled to land rights. That is something that will not stand with universal human rights. And therefore, it has to be rethought. Now, if you're just replicating it without something built into the system, and I'm sure Richard would want something built into the system, then you're not really going to give the quality of justice that people want. But here, I think with you, Tania, there's not really much difference between Richard and me. It's just a question of configuring the matter by reference to any local constitutional norms that put a limit on it, and giving a repeat product to people, but building in a reassessment of the norms so that a human being with a sense of justice is playing a part in delivering the product, which is justice, dignity, and human rights, and the rule of law.
That's a perfect lead into my final question, and I know that we're probably running over time, but Richard and Micheil, you've both talked about what you think the justice system of the future could look like. And it's also clear that there are some very significant differences between jurisdictions in terms of how that designing process takes place. For example, in China, the courts have used supportive replacement and disruptive technologies to build a whole range of justice apps so that now you can run a court case from start to finish using WeChat. They've also built a smart court system which has some strong, if you like, AI components. In contrast, in the United States, the Institute for the Advancement of the American Legal System, IALS, has approached reform by basically saying, in terms of technological reforms, if you use these 18 different components in terms of case management, so that case management is more outwardly focused and more focused on ODR, then you will have a lot of technological forms that happen, and essentially there will be a smart court that is developed as a result of that. In contrast, in the UK, we've seen a really extensive reform project which has already commenced and assumes that a lot of physical courts will be replaced by virtual courts with attendant cost savings and greater convenience for people. And I think Richard refers to people being able to be involved in a court action from their kitchen table. And I think in your book, Richard, you draw a distinction between the approach taken by incrementalists in terms of justice design and radicals. And I think you put yourself more in that radical camp. So Richard, in terms of this, and it's almost a return to the first question, to what extent should judges be involved in these reforms? And it seems to me that in some jurisdictions, they're much more engaged with and are leading justice reforms. And in other situations, the reforms are being led more by the executive arm of the government, if it exists indeed in that format.
So thank you very much, Tania. I also just wanted to, because I've been flicking through, there's lots of questions in the Q&A, and I'm just sorry I can't address them all, not least from my old friend, shout out to John Zalesnikov, who's been working in this area for many years. To answer your question, and I'm biased because I've been technology advisor to the Chief Justice over here since '98, but I think judges simply have to be involved, not to have their experience and their insight and their commitment would be, for me, a fatal flaw. What I think we do need to move away from, however, is thinking that the future is simply a techno-charged version of today. I think there's a halfway house between the revolution and the evolution, which I call incremental transformation. You can't change the wheel in a moving car. We have massive court systems up and running. We can't just switch them off and introduce something online. But I think jurisdictions are not facing the reality if they think that simply grafting more and more bits of technology onto our old ways of working will suddenly develop into the kind of suite of online services and online courts that I and others are talking about. And so I think we've got to distinguish between an incremental approach where there is a vision, a point in the horizon to which one was moving in a stable, sensible way and testing as you go along, from frankly just seeking some low-hanging fruit and some quick wins and throwing technologies here, there, and everywhere and expecting there's going to be change. Let's be absolutely clear. The first 50 years of legal technology has been about adding technology onto old processes. So that's a little bit of a tangential rant there. But my big point is it's no longer a system designed by judges and lawyers for judges and lawyers. We of course need judges and lawyers' input, but I think that I would say it's necessary but not sufficient, because we really do need to be, and you've hinted at it, Tania, it's a design issue. And we now know in designing systems and processes, we should build these around the users rather than around the providers. But if anyone suggests that means that judges shouldn't be involved, I think that's misconceived. It does vary across jurisdictions. What I found over the years is that it's actually varies according to individuals. Some judges like personally to roll up their sleeves and get heavily involved and often lead reform programs with technologies at the core. Others will say it's not their specialty. But there's always a sufficiency, in my experience, of enlightened and active and technologically sympathetic judges that there's always a group to draw on. But the challenge we all face now, I think, is this idea of a multidisciplinary group that judges have to be comfortable sitting down with officials, with technologists, with court users, and collaboratively designing our court services in the future.
Thank you very much, Richard. I've been given a time wind up from the organisers and did want to return to Micheil Kirby, but there are so many interesting questions that have been raised on the Q&A session that perhaps I might refer to Micheil Paton and introduce Micheil, who's the Principal Legal Officer at the Australian Law Reform Commission. Just before I do that, I also want to pass on my regards to John Zalesnikov, who's one of my dear friends as well. So he's clearly influenced a number of us, Richard. So Micheil, if I hand over to you in terms of some of the questions that have come through, and in particular because I know that Micheil Kirby didn't necessarily have an opportunity to respond to that final design question.
What a wonderful conversation to be coming in on. I will thank the speakers shortly, but not before subjecting them to some of the Q&A or the cues that we have received from the audience. And I'll be going down in order for those which have been voted by the most other participants in the audience. The first is really phrased as a comment rather than as a question, noting that the advantage of the global coronavirus pandemic has been that many people, even last year, would not have had a bar of a remote court hearing, but have now become quite accustomed to it and have even decided it may have advantages. This openness should be leveraged to pursue more sophisticated ODR solutions that are orders of magnitude beyond remote versions of our current system. I think that really reflects a lot of Richard's comments earlier, but I will pause in case any other panelists would like to add any other comments on that context.
I'm keen to that Micheil has an opportunity because I hogged the last question. So Micheil, you've put priority on this.
Well, from my point of view, I don't think it's very interesting to talk about adapting the system that we have to use facilities like distance videos and webinar type techniques to deal with problems. I think that that's simply using new technology in the old circumstances, and that's going to happen anyway. What is interesting is the next question, that is to say, using the developments of algorithms and of the new technology as it continues to advance in order to deliver the product. And I think that is a much more complicated question, and it raises in Australia constitutional and other questions, and I think that's a much more difficult issue, because I see the input of the human spirit into the notion of what is justice as very important, and something that doesn't stand still, that changes over time. If I think of my own life, looking back at the attitude towards LGBT people in the early parts of my life, attitudes of hatred and irrationality, that has changed over time. But if you don't, as it were, adapt the input into the decision-making principles, then you're simply going to go on doing horrible things, and that needs to change. So I'm all in favour of the use of distant video links, such as we're now having, such as having Richard in London, which is wonderful, and joining us. But I think there are much more complicated questions when it goes down the track into the use of technology to actually monitor and deliver the justice product, because the justice product is a human thing. And we know this in Australia better than any, because of our Aboriginal people, and because our system of law and so-called justice did not adapt for their needs, and indeed denied their needs. And this is something which was only ultimately corrected, not by the parliaments of Australia, which had been operating since the 1850s, but by unelected judges in the High Court of Australia in Mabo and Queensland. And that is a reminder to us of the fact that the quality of justice is something precious and spiritual, or ethical, and not simply a mechanical product.
Thank you very much. A related question perhaps from one Julian Burnside is that he's asking us to set aside the Australian Constitution for a moment, putting it to one side. If artificial intelligence could be used to resolve disputes, would the concept of what constitutes justice shift over time?
I'm happy to jump in on that one, and then Richard might want to follow it up. I think that there has in fact been a really significant shift in terms of the definition of justice, certainly in the past by the Australian Productivity Commission, by the Commonwealth Attorney Generals and others, where they've really said there is the court is not the epicentre of the justice system, and in fact most disputes are resolved in a range of different ways before courts, and that you need to consider this broader view of justice when we talk about justice sector developments. And I did a chapter on this called A Broader View of Justice at some point, where you really show this winding pathway where courts are really at the end of that pathway and are not certainly where most people tread. And there is, I think, also that very famous quote by Galanta where he says, just as health is not found in hospitals, justice is not necessarily found in courts. And it really goes back to Richard's comments beforehand. So part of this is, I think, linked to the role of courts and judges within justice, which is, I agree, a really critical role. However, the justice sector of itself is a much larger sector and exists outside of courts. And in fact, I think Richard Susskind may have a more centralist view than I do about the role of courts, and that may be to do with how Australians also view it. So I think you can put aside the Australian Constitution, although not put it aside, but in terms of when and considering how we redesign the justice system, it's critical to consider what the role of the courts is into the future. And in that regard, think about judicial leadership in the context of the courts, but also think about the numerous justice apps, the ODR schemes, the ADR schemes, and the other arrangements that currently already exist to help people with their disputes, and think about how technology can be integrated with some of those systems and schemes.
I wonder if I might just throw a little bit in. One of the things that struck me when I've writing my book on online courts was that both opponents and supporters of online courts invoke justice, either in support of or against the idea. And so I put on my hat as a former, I used to teach jurisprudence in Oxford, and it occurred to me as I wrote the book, and frankly over the years, that lawyers and judges and critics all use the term justice rather loosely. And it seemed to me that there's at least 7 different conceptions of justice used in discourse about online courts and courts generally. We should want substantive justice, which means that the decisions of our courts are fair. We should want procedural justice, which means the process is fair. We should want open justice, which means our courts are transparent. We should want distributive justice, which means our court services are accessible to all. We should want proportionate justice, which means that often the amount at issue or the nature or the extent of the action is somehow consistent with the scale of the dispute. We should want enforceable justice, that's to say backed by the coercive powers of the state. And we should also want what I call sustainable justice, that any changes we make, what we put in place is a sufficiently resourced system. Now, what we have often in debates about the future of online courts and the future of courts is actually different conceptions of justice pooling in different directions. I don't have time to resolve these issues today, but what I do encourage people to think about before people say things like, oh, there'll be less or more justice, to appreciate that it's a more nuanced concept. It's not an indivisible, monolithic concept. It's subtle, and that reflects the subtlety and, frankly, the significance of what's in dispute, of what's in discussion today.
Thank you both.
We're not mechanics, and once, there has to be an ethical element in the law, and I don't think anybody denies that. It's a question of how you introduce it, and it's not very ethical, as Richard has repeatedly pointed out, for a legal system to be beautiful but to be so expensive that people can't get to it. So, that's been an ethics that we put up with for too long, and this is a point in his writing that he repeatedly points out that ethic is over. But how we now get a new ethic which doesn't forget that simply repeating what has been done in the past is often a formula for unethical or unjust outcomes. They can be all those forms of injustice. And I'd add another one, constitutional justice, because at least in a country like Australia, you've just got to live with the Constitution. It's very hard to change.
Thank you all for those. I'll press on with a last couple of comments before we close up. I'm conscious of the time. There have been a few questions along these lines of what types of disputes are we talking about. This particular question asks whether we are only considering civil disputes in the context of automation, or could we really consider criminal hearings, constitutional hearings, administrative law hearings, and the complexity that they contain, could those also really be handled by AI? And another person asks about appeal processes as well, and also references the Mabo case. So is it particularly civil disputes that you think might be the first port of call, Richard, in these kinds of new methodologies?
What troubles me a little bit, the question is, I understand people do this, but jumping to AI, because there is a debate about the role of AI, and I'm very excited to read Tania's book on it. But as Tania herself has said, this is some years away. What I'm talking about primarily is pragmatic technology-based alternatives that can work today. And if the question is, can you settle some family disputes, for example, by video hearing? Can you settle some administrative disputes? Yes, of course you can. I mean, the big question, the big unanswered question for each jurisdiction is what kinds of cases are suitable, what kinds of cases aren't suitable for these remote hearings. And we really are thinking that is fairly primitive. I wouldn't want to be as broad brush to say you can't do this in this kind of case, because it's often, as we know, for example, very low value cases can raise very complex legal issues. Very high value cases may not raise complex issues. We find over in England that remote courts have worked very, very well in complex commercial cases, and less well when there's deep personal interests involved of individuals. So I think it's primitive, and it's too early to say. The only thing I did want to add was that the most difficult area, I think, is criminal. It's not at all obvious to me how we conduct serious criminal trials if physical courtrooms are shut. And it may surprise people to hear, I'm not a fan of the virtual jury where jurors sit at the kitchen table. I don't think the answer is dropping the jury system into Zoom. But that's our biggest difficulty, how it is we keep the serious crime managed if we have periods of significant further periods of lockdown.
Thank you. Did anybody else want to add in anything there? Otherwise, I'll move to one more. The next question is about judges and whether they can be expected or should be expected to understand and properly implement advanced technological techniques such as machine learning and artificial intelligence, and what sort of interdisciplinary work needs to be done to ensure that a technologised courtroom is independent, impartial, and achieves its purpose.
Well, the question here, it seems to me, is whether you're asking that judges as judges will, as it were, do this on the run as part of their judicial work, or whether this is going to be using judges in an advisory capacity as part-time members of the Law Reform Commission or full-time members of the Law Reform Commission on leave. I think that's a very different matter. Of course we should be using judges because they're extremely experienced and serious-minded players, and they can even sometimes throw off their old prejudices and attitudes of the past. And so the problem is, are you wanting to build this in so that you've got a constitutional problem, you go to number one court of the High Court in Canberra and you ask the High Court machine to tell you what the outcome is? Well, that's not going to happen in my lifetime. I don't think it's going to happen for a very long time, and I don't think our constitution would permit it. And therefore you'd have to change it first before you tried to introduce this. But there's a lot that can be done in the meantime. In the technology of delivering the product, I've got no problem, and I don't think there's any ultimate difficulty of building in the system. And of course you should consult and use judges. But in the actual delivery of the product, that's a much more tricky problem, and that does present constitutional problems for us in Australia.
I probably have a slightly different view to Michael's, in that I do think that our judges of the future require a much higher level of technological competence than they have had to date. And that is because I think that they need to be much more involved in leading the reforms that are coming, I think, quickly in terms of technological change to the court system. Whilst I totally accept and agree with Micheil that in a place like Australia, we can rely on the excellent Australian Law Reform Commission to advise judges in terms of pathways forward, and certainly to advise our politicians on areas of reform, we also need to have judges who are able to lead these reforms in every court, and we need to have judges who understand the implications of not just the issues that may arise in cases that they're dealing with, but certainly the issues that are arising in terms of reform of the system. So
I may have misunderstood the question, but I think it's right to tell our participants that, as many of them would know, that the High Court of Australia, the Federal Court of Australia, the Court of Appeals in New South Wales and other states have all introduced video links, and they're all using distance hearings, and the judges of today are getting involved in it just as I'm getting involved in Zoom, and you end up actually rather liking it, and it gives you opportunities to see and meet and dialogue that maybe you wouldn't have had before. So but I agree, there's a need for legal education, ongoing judicial education, but that will come, and judges are fast learners, especially when it just has to be done. And all of the courts are now operating with the use of Teams or Zoom or any of the other technologies, and that will expand.
And I will it'll fall to me now to give a vote of thanks to all of the speakers to wrap it up. It has been a really fascinating conversation, and we are very lucky to have had such eminent panelists to carry it through. I think it was really palpable, the passion that Richard shows in his presentation, and a real challenge to all of us to utilise available technologies to transform courts and the legal system more broadly to really deliver justice in a number of different ways, as he outlined, for people as they are intended to do. So thank you very much, Professor Richard Susskind. It is always a privilege to hear from the Honourable Micheil Kirby as well, and today in his capacity as patron of the Australian Society for Computers and Law. We've benefited again from his wisdom, his experience, and his ability to be able to look beyond what is, but not to be blinded by what is, but to imagine what could be. And it's been very timely also to hear from Professor Sourdin at a time when she's imminently publishing further work in this area. So thank you very much, Tania, for skillfully guiding the conversation with the two other panellists today, and for providing your own significant insights as well. Very briefly, today's conversation has been of great interest to the Australian Law Reform Commission for a number of reasons. Firstly, just because courts are so significant in our legal system, and any significant changes in their operations and functions is likely to have a real impact on our inquiry work and law reform projects. Also because the type of thinking that Professor Susskind was talking about, this outcome thinking and focusing on what people need rather than the needs of the systems that have been created, is really deeply relevant and appropriate in a law reform context. Finally, because of a new project that the Australian Law Reform Commission has been embarking on over the last year or so, consulting experts and the public about what our future inquiry topics should be, such that we've been able to suggest a program of work for the next few years to the Attorney General, what the ALRC could be doing. We're now seeking feedback from the public about our suggested program of work, and we're in the middle of a series of webinars for that purpose. Please do visit our website to find out more about that. Earlier in this week, we had a panel of experts discussing the need for law reform in administrative law to take into account the increasing use of automated decision-making by government departments. We have another this coming Monday talking about social enterprises, and the following week looking at press freedom. And the audience for this event will no doubt be made up of people who are interested in thinking about the future of Australian law. So we would also be very keen to hear from you on our future inquiry topics. And so please do feel to be in touch with us about that. And with that, I'll hand back to Marina for some final announcements.
Thank you, Micheil, and to our wonderful speakers. I'm so inspired by your generosity in giving your time, your expertise. holding to very high ideals on justice, equality, fairness, and human dignity. It has been truly inspirational. Thank you for your time again. Just as a quick reminder in terms of our upcoming events, on the 25th of this month, we'll be hosting Technology, Competition and Multilateralism. They'll be presented by the Director General of the World Intellectual Property Organization, Francis Scurry. He'll be joined by a panel of exceptional leaders, Dr. Ian Opperman, our Chief Data Scientist, Jenny Gordon, Chief Economist for the Australian Department of Foreign Affairs and Trade, and Sally Ann Williams, who is CEO of Circadia Innovations. We have a number of other events coming up in these next few weeks, including webinars on AI standards, cybersecurity in the university sector, and privacy as a right or privilege. But of course, if you're looking for something a little more social, why not join our Science Fiction Meets Science Fact online book club, which is due to launch on the 1st of October. Thank you so much for joining us this evening. Enjoy the rest of your day or evening. Thank you again to our wonderful panelists. Bye for now.